Sitting is open. Please be seated. The court meets today and will meet in the coming days to hear the oral arguments of the parties on preliminary objections raised by the respondent in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russian Federation, 32 states intervening, as well as the oral observations of the intervening states with respect to the subject matter of their interventions. This morning, the court will hear the first round of oral argument of the Russian Federation. I recall that since the court included no judge of Ukrainian nationality upon the bench, Ukraine proceeded to exercise the right conferred upon it by Article 31, Paragraph 2 of the statute, to choose a judge ad hoc to sit in the case. It chose Mr. Yves Daudet, who was duly installed as judge ad hoc on 7 March 2022, during the phase of the present case that was devoted to the request for the indication of provisional measures submitted by Ukraine. I shall now briefly recall the principal steps of procedure in the case. On 26 February 2022, Ukraine filed in the registry of the court an application instituting proceedings against the Russian Federation concerning, I quote, a dispute relating to the interpretation, application, and fulfillment of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, end of quote. I shall refer to this treaty as the Genocide Convention. In its application, Ukraine seeks to base the court's jurisdiction on Article 36, Paragraph 1 of the Statute of the Court, and on Article 9 of the Genocide Convention. Together with the application, Ukraine submitted a request for the indication of provisional measures with reference to Article 41 of the statute and to Articles 73, 74, and 75 of the Rules of Court. On 7 March 2022, a public hearing on the request for the indication of provisional measures was held, at which only Ukraine presented arguments, the Russian Federation having indicated by a letter dated 5 March 2022 that it would not participate in the oral proceedings on the request. After the closure of the hearing on that request, the respondent transmitted a document setting out its position that the court lacks jurisdiction in the case. By an order dated 16 March 2022, the court indicated the following provisional measures. I quote, 1. The Russian Federation shall immediately suspend the military operations that it commenced on 24 February 2022 in the territory of Ukraine. 2. The Russian Federation shall ensure that any military or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control or direction, take no steps in furtherance of the military operations referred to in point 1 above. 3. Both parties shall refrain from any action which might aggravate or extend the dispute before the court or make it more difficult to resolve. End of quote. By an order dated 23 March 2022, the court fixed 23 September 2022 and 23 March 2023 as the respective time limits for the filing of the Memorial of Ukraine and the Counter-Memorial of the Russian Federation. The Memorial of Ukraine was filed on 1 July 2022. On 3 October 2022, within the time limit prescribed by Article 79 bis, Paragraph 1 of the Rules of Court, the Russian Federation raised preliminary objections to the jurisdiction of the court and the admissibility of the application. Consequently, by an order of 7 February 2022, having noted that by virtue of Article 79 bis, Paragraph 3 of the Rules of Court, the proceedings on the merits were suspended, the court fixed 3 February 2023 as the time limit within which Ukraine could present a written statement of its observations and submissions on the preliminary objections raised by the Russian Federation. Ukraine filed its written statement within the time limit thus fixed. Between 21 July 2022, 33 states filed declarations of intervention under Article 63, Paragraph 2 of the Statute of the Court. I recall that Article 63 of the statute provides as follows, I quote, 1. Whenever the construction of a convention to which states other than those concerned in the case are parties is in question, the registrar shall notify all such states forthwith. 2. Every state so notified has the right to intervene in the proceedings, but if it uses this right, the construction given by the judgment will be equally binding upon it. End of quote. Pursuant to Article 83, Paragraph 1 of the Rules of Court, the parties presented written observations on the declarations of intervention that had been filed in the case. In light of the objections of the Russian Federation to the admissibility of all the declarations of intervention, the Court, pursuant to Article 84, Paragraph 2 of the Rules of Court, decided to hear, by means of a written procedure, the parties and the states seeking to intervene on the admissibility of the declarations of intervention. On 13 February 2023, the states seeking to intervene presented their written observations on the admissibility of the declarations of intervention, followed by the written observations of the parties on that same question on 24 March 2023. By an order dated 5 June 2023, the Court decided that the declarations of intervention under Article 63 of the statute submitted by the following 32 states were admissible at the preliminary objection stage of the proceeding, insofar as they concerned the construction of Article 9 and other provisions of the Genocide Convention that are relevant for the determination of the jurisdiction of the Court: Australia, Austria, Belgium, Bulgaria, Canada and the Netherlands jointly, Croatia, Cyprus, Czechia, Denmark, Estonia, Finland, France, Germany, Greece, Ireland, Italy, Latvia, Liechtenstein, Lithuania, Luxembourg, Malta, New Zealand, Norway, Poland, Portugal, Romania, Slovakia, Slovenia, Spain, Sweden, and the United Kingdom. The Court indicated in that order that it would not, at the preliminary objection stage, have regard to any part of the written or oral observations of the intervening states going beyond the scope thus fixed. In its order of 5 June 2023, the Court further found that the declaration of intervention under Article 63 of the statute submitted by the United States was inadmissible insofar as it concerned the preliminary objections stage of the proceedings. The Court also fixed 5 July 2023 as the time limit for the filing of the written observations referred to in Article 86, Paragraph 1 of the Rules of Court by the states whose declarations of intervention had been deemed admissible at the preliminary objections stage of the proceedings. The intervening states filed their written observations on the subject matter of the intervention within the time limits thus fixed. Liechtenstein, however, did not file written observations. After ascertaining the views of the parties, the Court decided, pursuant to Article 53, Paragraph 2 of its rules, that copies of the written pleadings and documents annexed would be made accessible to the public on the opening of the oral proceedings. Further, after consulting the parties and the states which had filed a declaration of intervention, the Court decided also to make accessible to the public the copies of the written pleadings and documents annexed would be made accessible to the public on the opening of the oral proceedings. Further, after consulting the parties and the states which had filed a declaration of intervention, the Court decided also to make accessible to the public the written observations of the parties on the declarations of intervention pursuant to Article 83, Paragraph 1 of the Rules of Court, the written observations of the states seeking to intervene, and those of the parties on the admissibility of the declarations of intervention in accordance with Article 84, Paragraph 2 of the Rules of Court, as well as the written observations of the intervening states on the subject matter of their interventions referred to in Article 86, Paragraph 1 of the Rules of Court. In accordance with the Court's practice, these documents will be placed on the Court's website from today. I note the presence before the Court of the agents and counsel of the two parties, as well as the representatives of the intervening states. I recall that in its order of 5 June 2023, on the admissibility of the declarations of intervention filed in the present case, the Court took note of the concerns expressed by the Russian Federation and stated that it was incumbent on the Court itself to organize the proceedings in a manner which ensures the equality of the parties and the good administration of justice. The Court indicated in that order that it would ensure that each party would have a fair opportunity and the necessary time to respond to the observations of the intervening states. The Court has taken these considerations into account in the organization of the present oral proceeding. In accordance with arrangements for the organization of the proceedings which have been decided by the Court, the hearings will comprise a first and second round of oral argument of the parties, as well as 2 sittings for the oral observations of the intervening states between those 2 rounds. The first round of oral argument will begin with the statement of the Russian Federation today from 10 a.m. to 1 p.m. Tomorrow, Tuesday, 19 September, Ukraine will present its first round of oral argument from 10 a.m. to 1 p.m. On Wednesday, 20 September, the intervening states will present their oral observations. The second round of oral argument will begin on the morning of Monday, 25 September. The Russian Federation will have 2 sessions of 3 hours on that day to respond to the arguments of Ukraine and the oral observations of the intervening states. The second round will conclude on the afternoon of Wednesday, 27 September. Ukraine will have a single session of 3 hours to respond to the arguments of the Russian Federation and the oral observations of the intervening states. In this first setting, the Russian Federation may, if required, avail itself of a short extension beyond 1 p.m. in view of the time taken up by my introductory remarks. I shall now give the floor to the President of the Russian Federation, His Excellency Mr. Gennady Kuzmin. You have the floor, Excellency.
Madam President, distinguished members of the Court, I'm pleased to appear here before you as the agent of the Russian Federation and present Russia's position. These hearings are devoted to the Genocide Convention, time-honored instrument adopted in the wake of Second World War to ensure that the crimes of the Nazi regime are never repeated. My country was an active elaborator and has always been a strong supporter of the Convention, of which it is a party for almost 70 years. Prevention and punishment of genocide are the object and purpose of the Convention. However, Ukraine is not accusing Russia of committing genocide. Ukraine is also not accusing Russia of failing to prevent or punish genocide. On the contrary, Ukraine insists no genocide has occurred. That alone should be enough to reject the case, because, according to the court's jurisprudence, if there was no genocide, there cannot be a violation of the Genocide Convention. What Ukraine complains about is Russia allegedly abusing the Genocide Convention as a pretext for recognizing the independence of Donetsk and Lugansk People's Republic and conducting the special military operation. It cannot be further from the truth. Firstly, it is a well-known fact that Russia launched the SMO under Article 51 of the UN Charter, which provides the right of individual and collective self-defense. This right is not affected at all by the Genocide Convention. Secondly, in order to complain about the abuse of right, one must first establish such right. Ukraine seems to claim that the Genocide Convention provides some kind of right to use force, which Russia allegedly abused. But the Convention, of course, provides no such right. Nor had Russia ever claimed it does. The pretext that Ukraine uses to drag this case into the courts is apparently Russia's officials using the word genocide when describing what Ukraine's forces have been doing with the people of Donbass for the past 9 years, ever since the current Russophobic neo-Nazi regime came to power in Kyiv by violently overthrowing the constitutionally elected president of Ukraine in 2014. However, making statements regarding genocide cannot be illegal under international law, including the Genocide Convention. The statements are unsurprising given the fact that Kyiv launched in 2014 a full-scale war against Donbass. Its policy to brutally quash any dissent, obstruct journalists, and promote hatred against ethnic Russians. The current Kyiv regime glorifies Nazi war criminals, adopts Nazi symbolism, and does not ban neo-Nazi groups. At the same time, Kyiv bans education of the Russian language and pushing the Russian language out of all spheres of public life. Russian books, films, and Russian artists are banned. Russian Orthodox churches are violently seized by Ukrainian security forces and neo-Nazi militants. The predominantly Russian people that lived in the southern and eastern Ukraine strongly opposed the 2014 coup new neo-Nazi policy. In response, Kyiv imposed a suffocating blockade on Donbass, robbing their populations of access to water, food, electricity, medicine, and other critical goods, and launched the so-called anti-terrorist operation, deploying military force against its own population, igniting a civil war. Russia tried to peacefully resolve the civil war in Ukraine. Russia actively participated in Normandy format negotiations and trilateral contact group to develop solution for Ukrainian crisis. It was the Russian president who first proposed to deploy UN peacekeeping units in Donbass. Ukraine impeded that initiative. Nevertheless, Russia's efforts brought results. I'm talking about conclusion of the Minsk Protocol dated 5th September 2014 and Minsk II agreement dated 12 February 2015. These are the only agreements concluded in relation to Ukraine's crisis. More than that, Minsk II was endorsed by the UN Security Council resolution. The Minsk agreements provided for ceasefire, ban on heavy weaponry and drones, amnesty for participants to the conflict. Importantly, the agreements envisaged the reintegration of the DPR and LPR into Ukraine on the condition of a constitutional reform in Ukraine and providing DPR and LPR greater autonomy. However, neither Ukraine nor its Western handlers ever intended to fulfill these UN-approved agreements. Today, all of them, Ukraine's President Poroshenko and Zelensky, Germany's former Chancellor Merkel, France's former President Hollande, proudly declared that Ukraine was never expected to implement the Minsk agreements. Instead, the agreements were supposed to give Ukraine breathing space and time to beef up its military power. In another case before the court, Russia had already emphasized that even the majority of the people of Ukraine wanted the Donbass conflict to be resolved by peaceful means. But nobody in the Ukrainian government heard those voices. President Zelensky cynically exploited the peaceful aspirations of people in eastern Ukraine during his election campaign, promising heal Donbass and stop the shooting. However, the Kyiv regime once again deceived its people. The violence never stopped, and Ukrainian officials openly mocked a military solution for the Donbass problem. For instance, Ukrainian Deputy Prime Minister Alexei Reznikov, in charge of so-called reintegration of temporarily occupied territories, called Donbass a mentally ill territory and a cancerous tumor that could be cut out. Reznikov was not fired for these words. On the contrary, he soon became the Ukrainian Minister of Defense. Talking about how Ukraine would deal with Donbass, Reznikov gushed about Croatia 1995 Operation Storm and Operation Lightning, which led to the complete expulsion of the Serbian population from this Balkan Republic. While planning Operation Storm, Croatian President Tudjman had said, "We have to inflict such blows that the Serbs will, to all practical purposes, disappear. And if we had enough ammunition, then I too would be in favor of destroying everything by shelling prior to advancing." When examining Serbia's counterclaim against Croatia under the Genocide Convention, the court had concluded that there had been ethnic cleansing on massive scale. Serbian civilians were arbitrarily killed by Croat forces and driven from their lands. Reznikov called these operations successful and said they ensured military reintegration. It's easy to see how Kyiv intended to deal with Russians from Donbass once it secured total control over the region. With the foreign aid, Ukraine built up its military capacity and kept bombing Donbass in violation of the Minsk agreements, all the while preparing for the final solution of the Donbass problem by force. By 2022, the conflict in Donbass had been ongoing for 8 years, with hundreds of thousands of ceasefire violations every year and a constant flow of hundreds of civilian casualties. By far, the most of the civilians were killed or injured by Ukrainian strikes on the DPR and LPR territory. In 2021, the number of ceasefire violations increased by more than 300% in comparison to 2020. As usual, the vast majority of strikes came from the Ukrainian side, with more than 75% of civilian casualties as a result of these attacks being reported in the DPR and LPR. Finally, in February 2022, the violence in Donbass spiked. As Ukrainian forces stepped up their attacks, nearly 2,000 ceasefire violations were recorded by the OSCE in a single day on the 21st February, including over 1,000 artillery and bomb strikes. Ukraine's single-minded drive to take Donbass by force overturned 8 years of diplomacy and negotiations. In a last bid to bring sense to warmongers in Kyiv, on 21st February, the Russian Federation has recognized the independence of DPR and LPR. However, this also failed to cool down Ukraine's desire to resolve the conflict through force of arms. The tempo attacks persisted on 22 February with almost 1,500 explosions along the contact line. It is in these circumstances that the Russian Federation, on 24 February 2022, took the decision to commence a special military operation. The President of the Russian Federation, in his publicly broadcasted speech on that day, explained the reasons underlying that decisions. First, the President expressly referred to Article 1 of the UN Charter and the principle of self-determination of peoples. Second, the President expressly referred to Article 51 of the UN Charter and the inherent right of a state to self-defense. Third, the President recalled the growing threat of NATO expansions into the territory of Ukraine and the futility of efforts to reach an agreement with NATO regarding equal and indivisible security in Europe. Fourth, the President referred to Russia's treaties on friendship with DPR and LPR and to the Republic's appeal to Russia for military assistance and self-defense under those treaties. And finally, the President also referred to Ukraine's violations of the UN Security Council Resolution 2202 upholding Minsk agreements. The reference to Article 51 of the Charter as the legal basis for the special military operation has been reiterated on this very same day by Russia's representative to the United Nations in his speech before the Security Council and the General Assembly, as well as in a letter to the Security Council and the United Nations Secretary General as a formal notification required under Article 51 of the Charter. None of these speeches or documents which express the official position of the Russian Federation contained references to the Genocide Convention. As to expressions of concern regarding the threat of genocide, as I said, they were unsurprising considering the policies of Kiev regime, which was firmly entrenched in the history, doctrines, and practices of Nazism. The Nazi roots of the Kiev regime come from the Organization of Ukrainian Nationalists, ООН, and its military wing, the Ukrainian Insurgent Army, UPA, which collaborated with the Nazis and took part in the massacre of hundreds of thousands of Jews, Poles, and Russians. These three are the founding fathers of Ukrainian Nazism. At the center is Stepan Bandera. He led the most radical faction of OON, the OON-B. OON believed that the alliance with Nazi Germany and its Führer Adolf Hitler was necessary to achieve this goal. Now you see the Ukrainian newspaper dated 31st July 1941, publishing the act of proclamation of the Ukrainian state signed by Bandera. It said that the newly created Ukrainian state will work closely with National Socialist Germany, which under the guidance of its leader Adolf Hitler is creating a new order in Europe. The photo on the right is Roman Shukhevich, commander of the notorious punitive battalion Ukrainische Sondergruppe Nachtigall. Two of the most heinous crimes in which the followers of Bandera and Shukhevich were involved, the Volyn massacre and Babi Yar massacre. In all, more than 5.3 million people died in Ukraine at the hands of the Nazis and their henchmen. Bandera and Shukhevich are both venerated by the current Kiev regime. Here you see Bandera's monuments in Lvov, Ivano-Frankovsk, and Ternopil. Now see Shukhevich monuments in Lvov. The leader of the second OON faction, OON-M, was Andrei Melnik. Here you see the archival photo from 1941 taken in Western Ukraine. On the arch hangs a poster, "Long live Hitler, long live Melnik." On the right is a modern monument to Melnik in Ivano-Frankovsk, Western Ukraine. The Kiev regime's own ideologists have admitted that OON-UPA was a typical Nazi organization. On the next slide, you can see a Nazi march in Dan Stanislavov, now Ivano-Frankovsk, Western Ukraine, 1941, and the march celebrating the 71st anniversary of SS Galichina Division founding, Lvov, Western Ukraine. In early 1990s, OON was legalized in Ukraine under the new title, Congress of Ukrainian Nationalists. Yuri Shukhevich, son of Roman Shukhevich, established and led another Ukrainian major neo-Nazi party, the Ukrainian National Assembly, UNA-UNSO. From these odious roots stem nowadays neo-Nazi movements in Ukraine, such as Svoboda, Trizub, Right Sector, Sich, and many others. You see a 2008 Congress of the Patriot of Ukraine movement in Kharkov. The speaker is Andrei Bieletsky, the future founder of the infamous neo-Nazi battalion Azov. The Patriot of Ukraine's official logo was the Nazi German Volksangel, which you can see on the banners. The same Volkshook can be observed on the Tiger tank of the Nazi SS Totenkopf division. The resurgence of neo-Nazi in Ukraine did not go unnoticed in the world. In 2008, the Jewish Telegraphic Agency published the alarming report on the widespread use of Nazi symbols and Nazi salutes in neo-Nazi mass events across Ukraine. These neo-Nazi groups became the driving force behind the violent coup d'etat, where armed neo-Nazi fighters overthrew the legitimate Ukrainian authorities and formed an illegitimate new government of victors, where a key position had been taken by neo-Nazi extremists. Here, the Svoboda neo-Nazi party members who joined the new government, shown with Svoboda's symbol, the Nazi Volksangel cross. Same background of these neo-Nazis available on the next 4 slides. This Ukrainian government glorifies the collaborators who fought on the side of Hitler during the Second World War. Those who are still alive are granted with veteran status, state protection and benefits. More than 200 streets across Ukraine have been named after Nazi criminals. On the next slide, you can see the SS Galiciana division being honored in Kiev. Neo-Nazi summer camps for children were opened all over Ukraine, indoctrinating children with the ideas of Bandera and hatred of Russians. Now, we hold President Zelensky naming a Ukrainian mountain brigade Edelweiss after the Nazi mountain division of the same name. Finally, here is a modern German Leopard tank of the Ukrainian armed forces, proudly bearing the notorious Nazi Balkan Kreuz, the white cross marking carried by Nazi army during their campaign in Poland and in USSR. On the international field, since 2014, Ukraine has been steadily voting against the UN General Assembly annual resolution on combating glorification of neo-Nazism and other practices that contribute to fueling contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. Madam President, in its order on provisional measures, the court found that Ukraine has a plausible right not to be subjected to military operations by the Russian Federation for the purpose of preventing and punishing an alleged genocide in the territory of Ukraine. However, that decision is preliminary in nature. When the court will decide on the jurisdiction of the case, it should bear in mind that this finding is not consistent with the court's previous finding in the legality of use of force cases. Back then, the court discarded Yugoslavia's request for provisional measures, despite Yugoslavia being the victim of an intensive bombing campaign by NATO forces. Numerous NATO leaders had referred to genocide as the legal basis for the operation. Representatives of NATO states have repeatedly stated so before this court. Just last year, Germany's Chancellor, Mr. Scholz, confirmed this in his dialogue with President Putin in Yugoslavia because, I quote, there was a danger and a threat of genocide, and this ought to have been prevented. NATO states had no other justification for their attack. They never invoked Article 51 of the UN Charter, nor did they have any ground to do so. No genocide was established to take place in Kosovo, Madam President, members of the court, according to this jurisprudence of the court, no jurisdiction can be awarded to Ukraine's claims. Deciding otherwise would be effectively a reversal of the position that the court took with regard to Yugoslavia's plea. Of course, Russia has always condemned the bombing of Yugoslavia by NATO and rejected NATO's attempts at justification. This confirms that Russia never believed that genocide convention to provide a legal basis for armed interventions. Ukraine's attempt to use an unrelated treaty in order to bring claims related to use of force and state recognition to the court, despite absence of jurisdiction, is nothing new. Back in 2008, another country, Georgia, much like Ukraine, attempted to re-establish control over two breakaway regions, Abkhazia and South Ossetia, by force, violating, like Ukraine, a UN-endorsed peace agreement, and even attacking Russian peacekeepers present under international mandate. Georgia, like Ukraine, attempted to mask the real nature of its dispute with Russia and drag the court into adjudicating use of force by window dressing its claims as falling under the treaty with a compromissory clause, in that case, the SERD. Back in 2011, the court has correctly decided that Georgia's claims rooted in the allegations of use of force did not pertain to racial discrimination. Summing up, Ukraine's legal position is hopelessly flawed and at odds with the long-standing jurisprudence of this court. Our legal arguments to this effect will be developed in more detail by our counselors. Madam President, Professor Hadi Azari will present Russia's first preliminary objection, namely that there is no dispute between Ukraine and Russia under the Genocide Convention. After that, Professor Alfredo Cruzado-Newman will continue with the second objection on the lack of the court's jurisdiction, ratione materia in this case. Professor Sin Hoi will explain Russia's third objection on the inadmissibility of new claims that Ukraine inappropriately advanced in its memorial, and the fourth objection on the lack of a fair utile of the prospective judgment upholding Ukraine's claims in this case. Mr. Kirill Udovichenko will further demonstrate Russia's fifth objection, that Ukraine's claims seek reverse compliance declaration and are therefore inadmissible, and will complete the presentation with the point that is clear to everyone in this hall, that Ukraine's claim in itself and its tactics in these proceedings is a manifest disregard of the proper administration of justice and constitutes an abuse of process. I thank you, Madam President, honorable members of the court, for your attention. I now kindly ask you, Madam President, to invite Professor Hadi Azari to address the court.
I thank the agent of the Russian Federation for his statement, and I now invite Professor Hadi Azari to take the floor. You have the floor, Professor.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam President. Members of the court, it is a great honor for me to appear once again before the court to present the first preliminary objection of the Russian Federation, in this case against Ukraine. My task is to demonstrate that there is no dispute under the 1948 Convention on Genocide, which should lead the court to decline its jurisdiction to entertain Ukraine's claims. The conditions of the existence of a dispute are very clearly specified in the court's jurisprudence, and I will summarize these in a few lines. For a dispute to exist, the court must establish, based on evidence provided by the parties, that on the date of filing the application, the applicant made a claim that was positively opposed by the respondent. The claims made by UK do not meet these conditions. In its first conclusion, Ukraine claims that there is no credible evidence that Ukraine is indeed responsible for committing genocide in violation of the Genocide Convention. This claim made by Ukraine is based on the supposed allegation of genocide that Russian Federation allegedly made against it. And to establish this, Ukraine has to prove that it has violated, first of all, the 1948 convention that Russian Federation made against it, and secondly, that this claim was positively opposed by the Russian Federation, and three, the disagreement existed on the date when the application was filed. Ukraine has been unable to demonstrate this. Firstly, Ukraine should have specified its allegation before instituting proceedings. In Georgia versus the Russian Federation, the court stated that the applicant, and I quote, must refer to the subject matter of the treaty with sufficient clarity to enable the state against which a claim is made to identify that there is or may be a dispute with regard to that subject matter. An express specification would remove any doubt about one state's understanding of the subject matter in issue and put the other on notice. End of quote. A dispute cannot exist between Ukraine and the Russian Federation under provisions of the 1948 Convention. Therefore, as to the purported allegation of genocide, Ukraine must identify the obligation stemming from this convention, which, according to it, Russia has allegedly violated. Needless to say that a dispute cannot originate from an obligation that doesn't exist. Ukraine must prove that the convention bans states from making allegations of genocide against each other. Ukraine has failed to meet this criterion. And this is hardly surprising because such an obligation simply doesn't exist, and a dispute cannot originate from an obligation that doesn't exist. In fact, this is the reason why, in the different formulations of the dispute submitted to the court, Ukraine does not rely on any provision of the convention to support this claim, contrary to what it has done for the other two claims. As you can see on the screen, the parts that are highlighted. Bringing up the Gambia versus Myanmar case is of no help to Ukraine, to the extent that in the court's judgment of 22nd of July 2022, the court did not dismiss the arguments supported by the Russian Federation. On the contrary, it confirmed them. The applicant states the court says, must refer to the subject matter of the treaty with sufficient clarity to enable the state against which a claim is made to identify that there is or may be a dispute with regard to that subject matter. End of quote. No claim was made by Ukraine that Russia had allegedly violated the 1948 Convention before filing its application. There was no evidence at all that was presented to the court demonstrating such a claim made by Ukraine against Russia. There is no note verbal addressed by Ukraine to the Russian Federation in which Ukraine exposes its opinions as to the fact that Russia's conduct was supposedly in breach of the convention. No claim similar to what Ukraine has presented in its application or its memorial was made against Russia before instituting the current proceedings. There is nothing at all in Ukraine's submissions demonstrating that it had informed Russia that it considered the accusation of genocide as being counter to Russia's obligation under the Genocide Convention. However, the court's established jurisprudence is unambiguous in this respect. It requires that the applicant should inform the respondent of its accusations, of its criticism, of its reproach, of its allegation before filing an application. And it was this condition that led to the court to specify in the Marshall Islands case that the application must demonstrate that the respondent was aware or could not have been unaware that its views were positively opposed by the applicant. And as the late Judge Trinidad explained, and I quote, the court effectively requires an applicant state to set out its legal claim to direct it specifically to the prospective respondent state or states and to make the alleged harmful conduct clear. Ukraine has not demonstrated this or done this. As a second step, Ukraine has to demonstrate that its claim was met with Russia's manifest opposition, and it has been unable to do so either because it was impossible to do so. There simply wasn't any claim requiring a reaction from the respondent. Ukraine was aware that it could not meet the standard of the existence of a dispute as required by the court. Therefore, it decided to reverse this standard. It strove to demonstrate that the Russian Federation had allegedly held Ukraine responsible for the violation of the 1948 Convention and that it expressed its positive opposition to the allegation of genocide. However, this argument simply disregards what is essential. The dispute raised by Ukraine is on Russia's responsibility under the convention and not on Ukraine's responsibility. And despite the fact that the rules of jurisprudence with regard to the existence of a dispute do not require this explanation, I shall nonetheless demonstrate that Ukraine's arguments are baseless, and I will address the issues in 2 points briefly. First of all, Ukraine makes a reference to the use of the term genocide in the declaration of Russian agents and authorities, and yet Ukraine has not proved that in these declarations the term was indeed used within the meaning of the 1948 Convention. As to a similar declaration in another context, the court declared, and I quote, "A statement can give rise to a dispute only if it refers to the subject matter of a claim with sufficient clarity to enable the state against which that claim is made to identify that there is or may be a dispute with regard to the subject matter." End of quote. It is perhaps noteworthy to recall that when these proceedings were brought to this court, William Shabazz published a very interesting study in which he explained the distinction that needs to be made between the use of the term genocide for rhetorical purposes or when it is used to invoke the convention. He begins his analysis by quoting the declaration of President Biden, who accused Russia of committing genocide by attacking Ukraine. Many other such declarations made in other contexts may be recalled. The ILC emphasizes that a state does not invoke the responsibility of another state merely because it criticizes that state for a breach and calls for observance of the obligation or even reserves its rights or protests. For the purpose of these articles, protest as such is not an invocation of responsibility. It has a variety of forms and purposes and is not limited to involving state responsibility. Ukraine contends that Russia has nonetheless invoked Ukraine's responsibility because, according to the ILC, as it says, the invocation of responsibility can be made by taking measures. And it says, and I quote, "In this case, Russia has not merely advanced allegations that Ukraine violated the Genocide Convention, but has taken measures against Ukraine on the basis of that allegation, that is to say, recognizing the DPR and LPR and using force in and against Ukraine." End of quote. To disprove Ukraine's argument, one only has to quote relevant sentences of the commentary of the ILC in which the words conveniently selected by Ukraine are used. And the ILC underlines, and I quote, "Invocation should be understood as taking measures of a relatively formal character, for example, the raising or presentation of a claim against another state, or the commencement of proceedings before an international court or tribunal. We cannot reasonably claim that the use of force or the recognition of a state can be considered as measures of a relatively formal character, as the invocation of responsibility of a state under international law. The investigative committee on which Ukraine relies to make its first claim doesn't really target Ukraine itself. The committee, as its name implies, conducts investigations on crimes and atrocities committed by individuals. This committee does not belong to the executive branch of the government. It does not represent the vision of Russia on the international level. More importantly, the committee has never conducted investigation on Ukraine's responsibility. This does not fall within its remit. If it did indeed target, even if it did indeed target Ukrainian officials, it wouldn't change anything, because for a dispute to occur, the court considers declarations and diplomatic exchanges between parties and the grounds presented by the authors of declarations and documents and the persons for which they are intended. In our case, the author of declarations is an organ that has the power to conduct investigations on international crimes committed by individuals without any judgment. However, Ukraine's argument is still against the practice of states with respect to prosecution of international crimes. Indeed, saying that the investigations conducted has created a dispute between Ukraine and the Russian Federation would be tantamount to recognizing, for example, that by exercising their universal jurisdiction, that the state tribunals have created, indeed, a dispute between the state of the tribunal and the individuals of that state presented for the said crimes. And such an assertion is, of course, baseless. Furthermore, supporting Ukraine would mean that one doesn't know the distinction between the international responsibility of a state and criminal responsibility.
Regarding the second point, Ukraine's reaction to the genocide declaration, it is obvious that in its written pleadings, Ukraine was unable to prove that it seriously opposed Russia's purported genocide declaration. Ukraine was aware that its position was weak, and so in its written observation tried to convince it that its silence meant it had rejected Russia's allegations. It argued that, given the seriousness of an allegation of genocide, the failure of a state to respond to such an allegation would constitute evidence that the allegation is rejected and dispute exists between the parties. Ukraine is wrong. It is not the magnitude of the accusation or its seriousness, but the existence of particular circumstances which require a reaction to determine whether silence equals reaction or not. There is nothing to prove that we are in such a situation. Anyway, Ukraine was not able to prove this. Besides, were one to believe Ukraine, no state would ever need to prove that its opponent had challenged its claim, and consequently, the very prerequisite of the existence of a dispute would be meaningless and would lose its raison d'être. At the opposite end of the argument I've just described, Ukraine claims that it did react nevertheless. In its written observations, it's recalled first Ukrainian authorities, to which it already referred in its memorial, and added a few additional examples. For example, but all the authorities had been looked into by the investigative committee, and the said authorities addressed the committee in their comments. So they did not respond to a state allegation, and their attitude cannot therefore be conducive to the arising of a legal dispute. The speech made by Mr. Kuleba, the Foreign Affairs Minister of Ukraine, on the 23rd of 2022, which Ukraine relies on with some insistence, is of no help to it. Nowhere in this speech is there reference to the 1948 Convention and its subject matter. Mr. Kuleba simply denied the allegations according to which Ukraine was preparing an attack in Donbass, and this was against the background, against the background of the United Nations Charter. The last argument is that its National Defense Act against the military operation of Russia constituted a rejection of its allegation of genocide. There again, Ukraine is wrong. It is not a defense against the special military operation which is in play here, but its manifest and clear rejection to the allegation of genocide. In a word, Ukraine has not demonstrated that it claimed a breach of the 1948 Convention and that his claim was opposed by Russia's reaction. It was not able to demonstrate either that Russia knew or could not ignore that Ukraine believed its genocide allegation as a breach of the Convention. Consequently, Ukraine did not prove the existence of a dispute with Russia regarding the first claim it submitted to the court. Madam President, distinguished members of the court, this brings me to the second dispute invoked by Ukraine regarding the recognition of by the Russian Federation of the DPR and the LPR and its use of force, which according to Ukraine constitute a breach of Articles 1 and 4 of the Convention. The Russian Federation has never claimed that the Convention, the Genocide Convention, authorized it to use force against Ukraine to comply with its Article 1 obligations, which is to prevent and punish genocide. According to the documents it sent to the court and to the UNSC, the Russian Federation invoked Article 51 of the United Nations Charter on self-defense and customary international law to legally underpin its conduct. Ukraine has used the pretext of the Commission of Genocide to ensure that conduct prohibited by international law, such as the use of force and recognition of states, fell within the scope of the Convention. As Judge Shui pointed out correctly, and I quote, Ukraine's contention that the Russian Federation's allegation of genocide against Ukraine is just an excuse for Russia's unlawful aggression raises doubt that this is a genuine case about genocide, an excuse for unlawful aggression between inverted commas. Needless to say, the court is not bound by the description of the subject matter of the dispute made by the applicant in its application. I quote, it is for the court itself to determine on an objective basis the subject matter of the dispute between the parties, that is, to isolate the real issue in the case and to identify the object of the claim, end of quote. The real issue, the real problem at issue in this case is not genocide, it's the use of force and the recognition of states under international law. It is with regard to these two purported disputes that the prerequisite of the existence of the dispute should be met before Ukraine introduced these proceedings. In its memorial and in its written observations, Ukraine devoted long passages to explaining that the Russian Federation had accused it of committing genocide and that it had rejected that accusation. Consequently, there is a dispute between the parties. Now, Ukraine is utterly mistaken. As I explained a while ago, to establish the existence of a dispute between the parties regarding the use of force and the recognition of states, Ukraine must first of all declared Russia's conduct to be in breach of its obligations under the Convention. Then it should demonstrate that this allegation was indeed opposed by Russia. It was unable to do so. Ukraine has made no claim regarding the use of force and the recognition of states, such that Russia would understand that there was a dispute, or there might exist a dispute between the two parties before the filing of the application. No evidence has been adduced by Ukraine proving that it had reproached the Russian Federation for the breach by its actions of its legal obligations under the 1948 Convention. The invocation by Ukraine of the declaration made by the Foreign Affairs Minister of Ukraine on the 26th of February 2022 is of no help whatever. That declaration was posted on the ministry's site at 39 minutes past 6 p.m. on the day on which the case was brought. In fact, only 4 hours before the filing of the application. Clearly, this was not a good faith attempt by the applicant to warn its opponent of the existence of a dispute between the parties before bringing the case before the ICJ. Russia could not be expected to be aware of this declaration in order to potentially express its opposition to its content. Let us recall that the court has taken account of the passing of a reasonable amount of time between the recognition of the existence of a dispute and the filing of the application. The rule according to which, and I quote, the dispute must in principle exist prior to the filing of the application, end quote, implies that the dispute has been crystallized, quote, prior to the date of the application, end quote, so that the defendant may be in a position to react to the applicant's claim. In the instant case, the Federation, the Russian Federation, was in no position to know that for its opponent, the actions at issue were in breach of its obligations under the Convention. For the same reason, it was not given enough time to react to its opponent's claims. It should be recalled that in the case matters regarding the obligation to prosecute and extradite, the court did not consider Belgium's note verbal to Senegal sent 2 months prior to the application, did not consider then that this was sufficient to warn the defendant as to the existence of the claim. Ukraine also argues that its minister's declaration is far more precise in its reference to the Genocide Convention, that, for example, the declarations made by Georgia before the filing of its application in the Georgia versus Russian Federation case. This argument does not stand up to scrutiny. This is the conclusion of the court invoked by Ukraine, and I will only read out the relevant sentences which are indeed underlined. The court observes that this decree does not allege that the Russian Federation was in breach of its obligations relating to the elimination of racial discrimination. Its concerns is with the allegedly unlawful use of armed force, end of quote. Why should things be different here regarding a declaration made by the Ukrainian Foreign Affairs Ministry in the present case? This declaration dealt with the purported illegal use of force by the Russian Federation and not some hypothetical breach of the Genocide Convention. The convention only entered into play because Ukraine considered it was a pretext used by Russia to intervene. Yet, at no point did the Ukrainian ministry declare that the so-called genocide allegations or the fact that Russia had relied on the Genocide Convention to undertake the special military operation constituted in and of themselves a breach of the Convention. Distinguished members of the court, Ukraine should have demonstrated that its claim, according to which the use of force and the recognition of the DPR and LPR in breach of the Convention, had met with the positive reaction of Russia before the filing of the application. But it did not do so. It could not have done so, since the military operation began at the same time as the filing of the proceedings, or the introduction of the proceedings. Therefore, since, in principle, the date for determining the existence of a dispute is the date on which the application is submitted to the court, the fact that the case was brought at the same time as the alleged breach of the convention means the prerequisites for the existence of a dispute could not be met. Both the applicant's claim of a breach of the convention and the defendant's reaction to the claim were made difficult by this, in fact, impossible. For there to be a dispute, it must be shown that the claim of one party is positively opposed by the other, quote unquote. Yet, in the instant case, there was neither claim nor positive objection. Ukraine was not able to demonstrate that it had accused Russia by its military operation and occasional regions of breaching any of its treaty obligations. It did not demonstrate either that Russia had opposed the views of the applicant. Consequently, Ukraine has not demonstrated there was a dispute with Russia regarding the second of its claims amongst those it submitted to the court. Distinguished members of the court, this brings me to the third part of my presentation on the purported dispute regarding the abusive use of the convention brought by Ukraine in its memorial. To justify this claim, Ukraine suggests three implicit obligations which, according to which, arise from the convention. You can find them on the screen, and I shall not read them out. I would simply point out that none of these conditions for the existence of a dispute are met in this claim. it should first be said that all these affirmations rely on false premises, according to which the Russian Federation had invoked Ukraine's responsibility for the Donbas genocide, and it then reacted unilaterally to put an end to it. The fact is that the Russian Federation did not invoke Ukraine's responsibility under the Genocide Convention, and did not react to put an end to it. Allow me, Madam President, to emphasize once again. To allege that a crime has been committed on a given territory is one thing. To invoke the responsibility of the state for that same crime, according to the rules of international law, is something quite different. Ukraine clearly indicated in its application that it did not consider that the state may use force or recognize states simply by relying on the convention. As I pointed out a moment ago, the Russian Federation did not allege either that such a right existed under the convention, either because use of force or the recognition of states rely on other sources of international law upon which Russia explicitly bases its actions. On its part, the court said clearly that, and I quote, "Moreover, it is doubtful that the convention, in light of its object and purpose, authorizes a contracting party's unilateral use of force in the territory of another state for the purpose of preventing or punishing an alleged genocide." End of quotation. When the parties on one hand, the court on the other hand, all consider that there is no right under the convention, can one seriously say that there is a dispute regarding this right? Surely the answer has to be no. It remains for me to point out that the Russian Federation was made cognizant of this claim by Ukraine when the memorial was filed. Yet, at the critical date of the filing of the application, this claim did not exist. There was no trace of the clearly opposed views of the parties at the time when the case was filed. Under those circumstances, one cannot conclude that there existed a dispute opposing the parties in this respect. For all these reasons, and distinguished members of the court, the Russian Federation requests that the court find that it does not have jurisdiction to entertain Ukraine's application. Distinguished members of the court, this brings me to the end of my comments. I would like to thank you very warmly for your attention. I would ask you, Madam President, to give the floor to Mr. Alfredo Rosato.
I thank Professor Azari, and I now invite Mr. Alfredo Crosato to take the floor. You have the floor, sir.
Madam President, distinguished members of the court, it is an honor to appear before you on behalf of the Russian Federation. My task today is to present Russia's second preliminary objection, that the court lacks jurisdiction ratione materia to entertain Ukraine's claims. Ukraine has come to this court with only one potential basis of jurisdiction, Article 9 of the Genocide Convention. It provides that disputes relating to the interpretation, application, or fulfillment of the Convention, including those relating to the responsibility of a state for genocide, or for any of the other acts enumerated in Article 3, may be submitted to the court. Ukraine submits that Russia has violated Articles 1 and 4 of the Genocide Convention. But it is evident to all, and simply undeniable, that this case is not about whether Russia has failed to prevent or punish genocide, contrary to its obligations under the Convention. What this case is really about is the legality of the special military operation and the recognition of the DPR and LPR as states. The legality of these actions not under the Genocide Convention, but under the UN Charter and customary international law. The entire case before you hinges upon this. This, Madam President, members of the court, calls for caution. Accepting Ukraine's position would be tantamount to rewriting the Convention and transforming its subject matter. It would completely overturn your well-established jurisprudence on the limits of compromissory clauses. it would be a clear circumvention of the fundamental principle of state consent to the jurisdiction of the court. My presentation will be as follows. I shall first make some general remarks about Ukraine's case. I will show that the claims of Ukraine do not concern the Genocide Convention, but other rules of international law. Ukraine's attempt to shoehorn those claims into the Convention leads to several contradictory assertions and propositions that do not have any basis in the Convention. I shall then set out the test for establishing the Court's jurisdiction rationale materiae under a compromissory clause, and recall what the Court has said about the scope of Article 9 in previous cases. The Court has already carefully delineated its jurisdiction under this provision. It does not confer upon the Court the powers that Ukraine seeks to rely on. I will then show that Ukraine's key contentions in this case are fundamentally wrong as a matter of international law. First, there is no obligation under the Convention to act within the limits of international law so as to incorporate an indefinite number of obligations unrelated to the Convention. Second, and to conclude, I will show that there is no right under the Convention that could have been abused by Russia. Madam President, let me start with some general remarks on Ukraine's claims. Russia's second preliminary objection concerns conclusions C and D of Ukraine's memorial. Ukraine asks the Court to adjudge and declare that by using force and recognizing the DPR and LPR, Russia violates Articles 1 and 4 of the Genocide Convention. Articles 1 and 4 are well known, but it is important to recall what they say. Article 1 reads the contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law, which they undertake to prevent and punish. Article 4 provides that persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, whether they are constitutionally responsible rulers, public officials, or private individuals. One would expect an applicant under the Genocide Convention to claim that the contracting party had failed to prevent genocide or to punish its perpetrators. The applicant may request that those obligations be complied with by, for example, adopting measures to prevent further acts of genocide, prosecuting offenders, and making reparation to victims. These are, after all, the obligations laid down in Articles 1 and 4 of the Convention. Ukraine claims something quite different. It argues that these provisions have been breached through acts that have no apparent connection with the required conduct, the use of force, and the recognition of certain entities as states. Articles 1 and 4 do not refer to the use of force or to the recognition of states. The same is true for the preamble and other articles of the Convention, and for the drafting history. Ukraine's conclusions C and D are therefore, on any reading, foreign to the Convention, outside the scope of the Convention. The subject matter of the treaty simply does not deal with the use of force or the recognition of states. Ukraine cannot avoid accepting this simple truth, and this should be the end of the story. Yet Ukraine insists on transforming the scope of the Convention, advancing 3 propositions, all of which are seriously flawed. First, Articles 1 and 4 contain, in Ukraine's view, an all-embracing obligation to act within the limits of international law when preventing or punishing genocide. The effect of this alleged obligation will be to incorporate into the Convention all obligations of states from other sources of international law, and to expand beyond measure the Court's jurisdiction under Article 9. Second, Ukraine argues that a state may not abuse Articles 1 and 4 by using force against another state or by recognizing states within the territory of another state, without sufficient evidence of genocide or a risk of genocide. This claim, based on an abuse of right, presupposes that the Genocide Convention confers a right on states to unilaterally use force, a right of humanitarian intervention, as well as a right to recognize states. Third, ignoring the court's jurisprudence, Ukraine suggests that Article 9 is a unique, broad, or wide compromissory clause. Since Ukraine's obvious goal is to have the court pass judgment on matters that do not fall within the subject matter of the Convention, its case is inevitably riddled with inconsistencies and surprising propositions. I will mention just a few. First, there is no doubt that an actual breach of the obligation to prevent or punish genocide is not claimed by Ukraine. In the Bosnian genocide case, the court clarified that the obligations to prevent and punish arise if genocide has been committed, or if there is a serious risk that genocide may be committed. The court also found that the state can be held responsible for breaching the obligation to prevent genocide only if genocide was actually committed. Ukraine's case is based on two contradictory premises. On the one hand, it states that no genocide has been committed in Donbas, and that there is no risk of genocide. So for Ukraine, the application of Articles 1 and 4 of the Convention have not been triggered. There being no genocide, Russia clearly cannot be held responsible for failing to prevent or to punish it. On the other hand, as I mentioned, Ukraine asserts that the Convention contains an obligation to act within the limits of international law when preventing or punishing genocide, and that Russia has violated this alleged obligation by breaching the UN Charter on customary international law. This logic is clearly not consistent with your case law. It makes no sense to say that Russia has violated an obligation to act within the limits of international law when preventing or punishing genocide, and at the same time, that in this circumstance, Russia had no obligation to prevent or punish. This convoluted reasoning confirms that the Convention is being instrumentalized to address a much broader and quite different dispute between the parties. Madam President, another flaw in Ukraine's case is the lack of a legal basis for the alleged right not to be subject to allegations of genocide, false or otherwise. This is related to Ukraine's most remarkable suggestion that the Convention may confer a right to use force against a state or to recognize states within the territory of another state for the purpose of preventing or punishing genocide. That is not only very controversial under customary international law, it has no basis whatsoever in the Convention. In its memorial, Ukraine suggests that states have an obligation to produce evidence of genocide before taking measures to prevent or punish, or before making an allegation of genocide. It argues that not doing so would contravene the limits of Articles 1 and 4, and that it has a right not to be subject to a false claim of genocide. At the same time, Ukraine appears to be of the view that when a state does have evidence of genocide, that state may act to the detriment of another state or may harm that other state. Ukraine does not define what detriment or harm means exactly, but it seems to refer, for the purpose of this case, to the use of force and the recognition of states. You may now see two excerpts on your screens. In the memorial, Ukraine states that Articles 1 and 4, at a minimum, require a state to conduct proper diligence before a state takes action to the detriment of another state for the purpose of preventing or punishing genocide. The implication here appears to be that if a state does conduct proper diligence, the Convention empowers it to take action to the detriment of another state, for example, by unilaterally using force. Ukraine also states that Articles 1 and 4 do not authorize, but rather prohibit one contracting party harming another contracting party under the guise of preventing and punishing a genocide that has been alleged without basis or due diligence. Here, Ukraine leaves a key question open: whether the Convention prohibits harming another state when the allegation of genocide is correct, or at least based on due diligence. Madam President, the Court no doubt applies the notion of due diligence, not as Ukraine suggests, to back up statements regarding genocide, but to establish whether a state has discharged its obligation to prevent genocide, where this obligation has been triggered. Mere allegations of genocide or of a risk of genocide do not constitute a breach of Articles 1 and 4. The Convention and its drafting history say nothing about the right not to be subject to an allegation of genocide. As noted by Judge Benuna at the provisional measure stage, the Convention does not cover, in any of its provisions, allegations of genocide. Ukraine seems to finally accept this in its written statement. But Ukraine's most remarkable suggestion, as I just showed, is that if a state has produced evidence of genocide, it may, under the Convention, take action to the detriment of another state or harm another state. This is a crucial aspect of the case before you. It lies at the heart of Ukraine's claims, and in particular, its reliance on an abuse of rights doctrine. Let us be clear. Accepting this proposition would be to say that the right of humanitarian intervention exists under the Convention. The Court is well aware that this notion has already been rejected by most members of the international community. For avoidance of doubt, I must recall that Russia's position on this matter, the use of force, is regulated by the UN Charter and customary international law, not by the Convention. The Genocide Convention does not authorize, confer a right, or impose an obligation to use force to prevent or punish genocide. Madam President, members of the Court, after these general remarks, I now turn to the test to be applied to establish the Court's jurisdiction ratione materia in this case. That test, in a nutshell, is whether a claim is capable of falling within the provisions of the treaty invoked by the applicant. To answer this question, the Convention must be interpreted to determine its scope and whether it may be breached in the manner alleged by the applicant. This is not a question of mere plausibility, a standard applicable at the provisional measures stage. The Court has a duty to ascertain that its jurisdiction is properly established before proceeding to the merits. This is well established in your jurisprudence. In the oil platforms case, the Court stated that the Court cannot limit itself to noting that one of the parties maintains that such a dispute exists and the other denies it. It must ascertain whether the violations of the Treaty of 1955 pleaded by Iran do or do not fall within the provisions of the treaty. The same test was applied recently in certain Iranian assets and in immunities and criminal proceedings. In applying this test, the Court is entitled to interpret the submissions of the applicant and to identify the object of the claim. In its written statement, Ukraine urges the Court to deal with the second preliminary objection at the merit stage. They suggest that the Court should accept Ukraine's factual claims as true. But this is beside the point. At this stage, the Court is called upon to interpret the Convention in the light of Ukraine's claims to ascertain its jurisdiction. A preliminary objection may be deferred to the merits if it raises complex questions of fact. Russia's second objection does not raise such questions. All the Court has to do is interpret Articles 1 and 4 and determine whether they contain an indefinite number of obligations through an alleged obligation to act within the limits of international law, or a right to use force and recognize states, considering that in the absence of such rights, there can be no abuse. I would also note, Madam President, an issue that Ukraine wrongly presents as factual. It asks the Court to accept pro term its own interpretation of Russia's legal justification for the special military operation and the recognition of the DPR and LPR. This is not a question of fact, but one of law. Russia is here today precisely to explain what its legal position is, as it is, of course, entitled to do. Madam President, I pause here if you think it appropriate to have the coffee break now, or I can continue for another 5 minutes.
Further, Mr. Posado, thank you.
Thank you. I now turn to your previous decisions concerning the scope of Article 9 of the Convention. These decisions leave no place for doubt. The Court's jurisdiction under Article 9 is limited to violations of the Convention itself. Your 2007 judgment in Bosnia genocide is particularly relevant. The Court said it has no power to rule on alleged breaches of other obligations under international law not amounting to genocide. That is so even if the alleged breaches are of obligations under peremptory norms, or of obligations which protect essential humanitarian values, and which may be owed erga omnes. This finding was unanimous. Sir Christopher Greenwood, writing as a commentator, explained that the court was able to rule only on the issues relating to the Genocide Convention and could not consider other aspects of the broader dispute between the two countries, such as the application of the international law on the use of force. The court reaffirmed this understanding in the Croatia genocide case. It was determined that Article 9 confines the court to disputes regarding genocide. The jurisdiction under Article 9 is confined to obligations arising under the Convention itself, and that the court can only rule within the limits imposed by the Convention. We note, Madam President, that Ukraine proposes a novel interpretation of Article 9 in its written statement. It suggests that Article 9 would give the court a broad, wide, or comprehensive jurisdiction. Ukraine puts emphasis, for example, on the word fulfillment, using a dozen dictionary definitions. They also provide an incomplete account of the drafting history of Article 9, focusing on a single statement at the Sixth Committee. And Ukraine quotes selectively the views of one. These arguments are wrong on several grounds, which we shall address in more detail next week. Today, I will stress only one. Ukraine completely ignores the interpretation of Article 9 that the court has already adopted. Indeed, your jurisprudence is clear. There is no reason to depart from it or to sweep it under the carpet. Ukraine is asking you to do exactly what you said you cannot do under Article 9, to pass judgment on and even order reparation for alleged violations of rules of international law that do not, cannot arise. Under the Genocide Convention, but under the UN Charter and customary international law. This could not be regarded as a case relating to the interpretation, application, or fulfillment of the Genocide Convention. So put simply, the violations of Articles 1 and 4 that Ukraine alleges are grounded or predicated on a violation not of the Convention, but of other rules of international law. Determining that Russia has violated those other rules, which Ukraine admits originate outside the Convention, is a sine qua non for its claim to succeed. Of course.
The sitting is adjourned.